Welcome, everyone, to the GIO HIPAA training. I'm Terry Daly. I'm an attorney with Mercer and happy to be providing this training to you. We are going to start this training with why we're all here, why we have to take this training, and most importantly, why it's important that we follow all of the procedures and all the protections that we talk about today. Then we'll get into the substance of HIPAA. And as you may know, there's two parts of HIPAA. There's HIPAA privacy. HIPAA privacy deals with all protected health information, whether or not that's oral, electronic, or written. The basic rule under HIPAA privacy is that protected health information can only be used for purposes of administering the health plan. It cannot be used, shared, disclosed, allowed to be accessed for any other purpose. Then we'll turn to, after we cover all the details of HIPAA privacy, then we'll turn to HIPAA security. HIPAA security deals with the same definition of PHI, which we'll cover in a few minutes, but it only covers protected health information that's in electronic form or ePHI. And the basic goal, the basic rule under HIPAA security is that um, you can only use you need to secure the storage and transmission of all electronic protected health information that the plan has. So after we cover the body of that, we'll end with another reminder as to why it's important that we follow these rules, and that is because the HIPAA security sanction policy. So let's start with why we're all here. HIPAA requires that anyone within the organization that could have access to protected health information be trained under HIPAA. And you have an obligation to follow these rules under HIPAA and to ensure that protected health information is not disclosed in an impermissible manner. Some of you on this call may deal with protected health information on a day-to-day basis. Some of you may very rarely or just incidentally have access to protected health information. Either way, you're required to be trained under the HIPAA rules and to follow these rules. There are significant financial penalties for failing to comply with HIPAA. It's also important to note that you personally could be held criminally liable for knowing and willful violations of these rules. Also, the company or you as an operator could be subject to significant negative public relations implications if HIPAA is violated. As I'm sure you're well aware, there's not a lot of consensus in Washington on lots of matters, but there is actually bipartisan consensus on protecting individuals' health information and the confidentiality of that information. So we are seeing a focus on that in Washington and in the enforcement of HIPAA. So all of those are just reasons why important that we pay attention today and most importantly, follow all of the HIPAA protections going forward. So let's now turn to the actual HIPAA requirements. And let's start with HIPAA privacy. Before we actually start with HIPAA, the requirements under HIPAA, let's talk for a few minutes about what information is subject to HIPAA. And let me also, before we even get into the definition of what information is subject to HIPAA, let me say that most employers, and I would think it's the case for you guys as well, most employers actually have more health information about their employees or dependents that is not subject to HIPAA. But just because information is not subject to HIPAA does not mean that it shouldn't be kept confidential. Any health information, whether or not it's subject to HIPAA or not, about an employee or a dependent, should be kept confidential. But what we're going to talk about today and what HIPAA applies to is what's called PHI or protected health information. So, what is protected health information? It's a three-part definition. It's individually identifiable information about someone's past, present, or future health condition or the provision of health care to that individual that is created, received, or maintained by one of the GIOA's HIPAA covered plans. So first, it has to be individual identifiable. Obviously, things like name, social security number, employee ID, email address, photo, all that kind of stuff would make it individually identifiable. But there's also a catch-all phrase that says anything else that allows for the reasonable identification. So the bottom line here is if you can identify to whom the information pertains, it should be treated as protected health information. The opposite of that, though, is if you get a report or have access to a report that says your plan or you paid, claims for 22 prescriptions last month for this particular prescription without any identifying information, that's not PHI. You have to be able to identify to whom the information pertains. Second, it has to be information about someone's health condition or the or the provision of healthcare to that individual. So, if Sue employee calls, writes, emails someone on the benefits team and says, "Hey, I'm having a problem with my claim," and as we all know, they like to tell their whole story about what the issue is and what their condition is and why they're having this problem, etc. That would be an example of individually identifiable information. It would be information about her health information, and it doesn't have to be both, it's either or the past, present, or future provision of healthcare to that individual. Finally, it has to relate to one of the GIOA health plans. Those include medical, dental, vision, prescription drug, EAP, and health FSA. So when you boil all this down, what are we talking about? We're talking about individually identifiable information about someone's health condition or the past, present, or future provision of benefits or health care associated with one of these plans. It does not include, and this is where all the other health information you may have or you may have access to comes into play. It does not include information about someone's short or long-term disability, ADA, FMLA, workers' comp, if you do drug testing, if Joe employee submits 10 pages of his medical records as to why he didn't show up for work yesterday, or why he needs a leave of absence, or why he needs an accommodation under the ADA, or why he's applying for a disability. Again, all that information should be kept confidential, but it is not subject to HIPAA. Protected health information can be in any form. It can be an oral conversation on the phone or in person. It can be a handwritten note. It can be a printed out email, a letter, a spreadsheet. It can be an electronic form. It can be an email. It can be a spreadsheet. It can be a PDF. Any of that. It can be in any form. As long as it's individually identifiable information related to someone's health condition or the provision of benefits related to one of those HIPAA plans, it's subject to HIPAA.
And so, Terry, kind of along that path, would you suggest that they have rules about clear desk policy so this documentation isn't left out, or where this information is stored if they
Yeah,
have?
we're going to get to that in one, not 1 minute, but probably 2 or 3 minutes. We're going to get to that in 1 second.
Perfect. Thank
So what are the most common examples of PHI? The most common examples of PHI are what you might call claim resolution or customer service, meaning, again, Sue employee calls, writes, emails, and is having a problem with their claim, right? Or about her kid's claim, or whatever the case may be. Um, Other examples of PHI are large claim reports, reports you have about claims paid, individual account balances in the health FSA, um, um, financial analysis done for the plan, all of that, if it's individually identifiable, would be protected health information. Let me just pause right there. Any questions? Let's see. Do we have a? Let me see if we have
Yeah,
a.
I don't see any questions in the Q&A, but I
We do
do
have one in
see
the
one question
chat.
in the chat. Yeah.
Yeah.
Is it return?
No, that is example of not. Remember when I said if someone submits 1,000 pages of their medical records for purposes of a return to work or for a leave of absence or for an accommodation for ADA, FMLA, any of that, that is not PHI subject to HIPAA. Now, if that same information came from the health plan or was maintained by the health plan, it would be PHI.
So return to works are not HIPAA.
Correct. The information submitted by the employee or by the employee's provider or for purposes of leave, return to work, any of that is not subject to HIPAA. Again, that should still be kept confidential, obviously, but it is not subject to HIPAA. Okay. Um, so any other questions before about what is and what's not PHI?
Nothing in the chat or the
Okay.
Q&A.
Okay. All right. So let's talk about then what does HIPAA say about when you can and cannot use, share, disclose, allow access to protected health information. I think some people have this misconception that um, uh, that you can never get or use or share or disclose protected health information. That's not the case. HIPAA allows you to use, to share, to disclose, to allow access to protected health information, but only for purposes of administering the health plan, what they call payment, treatment, and healthcare operations of the health plan. So let's go back to our common example where Sue employee calls, emails. Let's assume Sue emails someone on the benefits team or someone and says, "Hey, I'm having a problem with my claim," right? That person can share that information with other people within the organization that need it for purposes of resolving her claim. You may share it with the vendor, you may share it with Mercer, you may share it with your outside counsel, whoever needs it for purposes of resolving the claim. Same thing if you're doing financial analysis of the plan and you have a report of claims, you can share that with other people that need it for purposes of performing those plan administration functions. You cannot, though, share it, disclose it, allow other people to access it for any other reason. So you can't, if someone shares their protected health information for purposes of, again, resolving some claim issue, you can't share it with that person's boss. You can't share it you can't even share it with other people within the organization if they don't need it and they're not involved in administering the health plans. You can always disclose protected health information to the individual if it's their own PHI. So if Sue employee calls up and is saying, "I'm having a problem with my claim," or needs help with a claim, you can disclose Sue's PHI to Sue, as long as you verify the identity of Sue. You can also disclose the PHI of a minor child to the parent of that minor child. And a minor child is defined under state law generally as someone who is under 18. Other than that, absent legal authority, written legal authority, you cannot disclose someone else's PHI to another person. If an employee or asks you to disclose their PHI, sometimes people will ask, say, can you discuss this with so and so, with my spouse or with my mom or with my aunt or whoever or my supervisor or whoever. The only way you can do that is getting that individual to sign a HIPAA authorization form. Let me make it really clear. Do not rely on a verbal authorization with the person saying, "Oh, it's okay for you to disclose this," or an email saying, "Oh, it's okay to discuss this with Bob or Sue or whoever." There's very particular content requirements, what needs to be in a HIPAA authorization form. If you ever need that, reach out to the HIPAA um, officers
And
within the
Terry,
organization. Yes,
Terry, we actually have, if you were an operator, that form for your personal information was included during the strategy period. And it is also located on GIOA.info. And for your team members, those forms live in their enrollment portals that we launched this year. So those particular forms are out there as and the forms to revoke um, HIPAA authorization as well. So to authorize it or to revoke it are available to you.
perfect. So just to be clear, you don't need it for doing plan administration, but if you need it to disclose it to someone else or for some other reason, you need one of those authorization forms. All right. Like a lot of things in law or a lot of things in life, there's always an exception to the rule, right? And there's always been an exception under HIPAA for purposes of legal subpoenas and criminal investigations. So if you get a legal subpoena requiring you to disclose this information, it can be disclosed and not violate HIPAA. Last year, there were final regulations that put additional requirements on the disclosure of reproductive health PHI pursuant to a criminal investigation or legal subpoena. Those regulations were issued. Then there was a lawsuit in the Northern District of Texas, and that court vacated those final regs on a national level. That vacation, though, is being appealed. So the message for everyone on this training is in the very, very, very unlikely event you ever got a request to disclose PHI pursuant to a legal subpoena or a criminal investigation, stop what you're doing and refer that question to Justin Mize, who's going to serve as the HIPAA officer for the organization. And he probably in consultation with the council will take the appropriate action. So just don't take it upon yourself to try to respond to one of those. Okay. So we talked about what is PHI. We've talked about the only time you can use PHI and disclose PHI or allow access to PHI is for purposes of administering the plan, and it can only be disclosed to those people. Let's talk about HIPAA also requires, and goodness, this goes to your question earlier, the protections that you have to have in place to safeguard this information. So first of all, even when you are using PHI or disclosing PHI for purposes of plan administration, you should only disclose what they call the minimum necessary. There's what they call the HIPAA minimum necessary standard. So, so even if you're disclosing it for a valid plan administration reason, let's say, for example, Sue employee sends you an email and it's a 10-page long email string and you need to send part of that information to someone else or to some other entity for purposes of resolving her claim. You should not forward all that unnecessary information. You should either take out the relevant information and put it in a separate email or delete the unnecessary information. Also, where possible, if you can de-identify the information, that should also be done. So, for example, if there's a question about a claim and whoever you're disclosing that information doesn't need to know the actual identity of the individual, you should de-identify the information. Also, as I mentioned earlier, you should always verify the identity of the individual and make sure that it is appropriate to disclose the PHI before you make any disclosures of people's PHI. HIPAA also requires that you have take reasonable steps and apply safeguards to ensure that PHI is not accessed or disclosed in a manner not allowed under the rule. We're going to cover these in the next couple slides. Many of these are common sense. Many of these are good business practices I'm sure you're already doing, but we'll go through them now. This is Glennis's question about a clean desk. First of all, don't make unnecessary copies of PHI. Keep a clean desk, meaning don't leave someone's PHI on your desk or in an area that could be seen or viewed or taken by other individuals that don't need it for purposes of plan administration. Always secure hard copy PHI in a secure manner. Do not put someone's PHI in the regular trash can. Make sure you securely dispose of it as well. Electronic protected health information, we'll cover this in much greater detail in a few seconds on the security rules. But again, don't forward long email strings. Um, Pay particular attention to laptops and portable devices. Read and follow all of any IT security alerts. Um, and make sure your laptop and your workstations have appropriate locking screensavers. Faxes, if you still have a fax machine, um, if you still do use faxes, make sure that you put a cover sheet and confirm that it is received by the appropriate party. Oral conversations, um, don't discuss someone's PHI in a location or an area or in a manner that could be overheard by anyone else. Talked about verifying the identity of the individual. Don't discuss someone's PHI um, anywhere that it could be overheard by someone else. Do not leave someone's PHI on a voicemail. If you need to leave a voicemail for the individual to call you back. That covers the basic HIPAA. The last section of HIPAA privacy is some administrative sections. Let me just pause right there. Any questions about anything that we've covered? What is PHI, when you can use it, when you can't use it, and the protections that you have to apply to it?
Terry, I don't see anything in the chat, but I do have a personal question for you.
Sure.
Um, for those who work on laptops and maybe in offices where people come in and out, or as you
Mhm.
travel, if they're going to meetings, do you suggest a privacy screen on their laptops to ensure the data is private while they're out?
If possible, yes. Especially if the laptop is going to be in a location or in a situation where it could be viewed by someone else. There's no legal, the law doesn't say that. The law says you have to take reasonable safeguards to try to limit the exposure of this. Um, if you've got a locked office or no one's in your office, obviously it's not an issue. But if you're going to be viewing people's PHI around other individuals, then that would probably be a reasonable safeguard.
Thank you. And there are no questions in the chat.
Okay. So individuals have certain rights with regard to their own PHI. It is highly, highly, highly unlikely that you would ever get one of these requests. Um, if someone ever gets one of these, if you ever get one of these requests, stop what you're doing and refer that to Justin Mize, who can take the appropriate action. Um, Justin is going to serve as the HIPAA privacy and HIPAA security official. In general, we are better off with HIPAA. We are better off safe than sorry. So if you ever have a question or think there's been any issue, um, um, stop what you're doing and refer that to Justin. Um, the plan is required to issue a privacy notice, which it does. Um, you know, if sometimes employees will ask questions after receiving those. If they're simple questions, obviously go ahead and answer them. But if you need any assistance on that, again, you can refer that to Justin. Finally, the breach rules. HIPAA has very detailed rules about what has to happen, who needs to be notified, when they have to provide notification, what's the content of the notification, if there is ever a HIPAA breach. And a lot of people, a HIPAA breach includes what a lot of people think of a breach, where like there's a malicious hacking or stealing information, that kind of stuff. That's certainly a HIPAA breach. But technically, under HIPAA, a breach is any time PHI is disclosed in a manner not allowed under the rules. So this can be as simple as sending a spreadsheet with PHI in it to the wrong email address. It could be getting a laptop taken. It could be a FedEx package getting stolen or whatever the case may be. The real message for everyone on this call is if you ever even think about there could possibly be any issue, stop what you're doing and refer the matter to Justin, who can take the appropriate action. Don't take it upon yourself to try to resolve the situation. Obviously, stop whatever harm is being done by if there is a breach, but any fixing it or notice or anything like that, refer that to Justin. So that covers HIPAA privacy, HIPAA security.
Harry, can we pause for one
Yeah,
moment?
sure.
We have a few questions.
Okay, go for it.
The first question is, if a team member shares verbally with their leader that they are pregnant, is this considered PHI?
No. Um, if for example, so if I share if one of your employees shares that they are pregnant with their supervisor, their boss, the operator, whoever, that has nothing to do with HIPAA. But if there's a record from the health plan that she had a prenatal claim, that would be PHI.
Perfect. The next question is, will we receive Justin's email or contact information so they can be forwarded? So if you have a HIPAA question, you can reach Justin through the GIOA 411 line, which every operator has that phone number. So we will send that out post meeting with this recording. The next question is, do you have any real life examples of when a operator would have had any interaction with PHI? I only ask because I've been an operator for over 6 years and I cannot have this information in my possession. So, um,
And she might be
Terry,
the better one to answer that.
yeah, so Terry, they have access through our benefit enrollment platform to every bit of team member data, the plans they enroll into. Um, would you consider that PHI?
Yeah, so there's a special exception for eligibility and enrollment information, but that's only for employer maintained eligibility and enrollment information.
Which it
So
is. Which it is.
well, it is, but it's possible that it depends on where the information comes from. If it's eligibility and enrollment information that comes from the plan, then it would be PHI. But if it is the employer maintained eligibility and enrollment information, there's a special exception for that. I think the where it's coming from the GIO plan, I think there's a strong argument that that would be treated as PHI.
So, Tony, that is your access to PHI, which you do have access to pieces of that information. And then the other question is, does PHI apply to workers' compensation claims?
No, does not.
Right,
Doesn't
perfect,
apply to workers' comp, ADA, FMLA, leave of absence, return to work, disability plans.
perfect. I think that's all the questions in the chat because we just answered the other question.
Okay,
Thank you, Terry.
no problem. All right, so let's turn to HIPAA security. HIPAA security covers the exact same definition of PHI, individually identifiable information about someone's health condition or the provision of healthcare to them related to one of those HIPAA covered plans. The only difference here is, though, it has to be in electronic form. It can be either at rest, meaning in an electronic application. It could be in an email, it could be an Excel spreadsheet, it could be a PDF. It could be on a shared drive, a network folder. Any of those would be, as long as it's PHI, would be treated as electronic protected health information. What are what are your responsibilities as a user of electronic protected health information or someone who has access to electronic protected health information? There's really two things. One is you need to store that electronic protected health information only in a location that is restricted in access to those people that need it for purposes of plan administration. Do not ever store someone's EPHI in an application or repository or in a folder or a drive that is not restricted in access to those people that need it for purposes of plan administration. Second, if you are ever transmitting EPHI, so an email or a transmission to the vendor or to the board or anything like that, you need to always secure the transmission of that, either encrypting the email or password protecting the attachment, or using a secure vendor transmission protocol. Do not ever send someone's EPHI in an unsecured manner. Almost most of the breaches and most of the problems, many of the problems reported to the government with regard to electronic protected health information have dealt with laptops. If you have a laptop and it may contain or you use it to access protected health information, make sure you secure it. Make sure you follow all the organization's IT procedures about securing it. Keep it in your possession. Exit the programs when you're done with it. Do not leave it on the counter in the coffee store and go to the bathroom. Don't leave it on the bureau in the hotel room and go out to dinner. Just that's where most of the problems with regard to electronic protected health information have happened. Critical security risks, um, just like we covered many of the common sense, good business practices that we talked about safeguarding protected health information. The HIPAA security rules require that we train you on some critical security risks that could be a risk to the confidentiality or integrity of all this EPHI. Many of these, like we talked about earlier, are common sense. Many of these are good business practices. With regard to malicious software, don't open, most importantly, don't open any emails, don't click on any links, don't open any websites that are from suspicious or unknown sources. Report any of those to the HIPAA officer. Comply with any IT instructions to safeguard your IT infrastructure. Read and follow any alerts Um, if you are remote accessing into the network, make sure you follow all of the appropriate protections. If you become aware of any issues or think there could be any issues or any with regard to this information, stop what you're doing and refer that to Justin. Passwords, you're responsible for all actions taken with your password. Obviously, don't share your password. Don't leave a sticky with your password. Um, um, make sure you make your password private and difficult to discover and keep it updated consistent with company policy. Same thing under as HIPAA privacy. We're better off safe than sorry. If you ever have a question about how you should handle protected health information, whether or not it's electronic or not, or if you ever think there could be any issue, stop what you're doing and refer that to Justin, who can get the appropriate resources to handle that. Any questions about the HIPAA security?
At this time, I don't see any questions about security, but we do have one question, Terry.
Okay.
If their team member has an accident at work and they receive the medical information not related to the accident, is that additional information that is non-related to that accident now considered HIPAA?
It depends on if where it comes from. If it comes from the health plan, meaning if they get, or, if they get information from the health plan about, oh, Bob had, we paid a claim for Bob's bad back, or Bob had this laceration to his arm, or whatever whatever the situation is. If it came from the health plan, it would be PHI. If it came, though, from a workers' comp claim or just as a result of the first aid that was provided to that individual, or again, for purposes of a leave or any other reason, it would not be subject to HIPAA. I think, but again, remember, just because it's not subject to HIPAA doesn't mean it should still be kept confidential.
Thank you, Terry. There are no more questions at this
Okay.
time.
All right. We started, remember, in the very beginning about how there's penalties and enforcement of these rules, and that why it's important that we follow all these rules. We're just going to end with one more reminder, and that is HIPAA requires that the organization have a sanction policy, meaning an action that it will take against you if you don't follow these rules. And those sanctions include and as mandated under HIPAA, include anything from verbal warning all the way to termination. So just another reminder, just make sure we follow these rules. And again, any questions, we're better off safe than sorry when we deal with personal health information. Any questions at all should be referred to Justin. Um, Otherwise, that concludes the training, and I'm happy to answer any other further questions that you may have.
If you have any questions, you can drop them into the chat or the Q&A feature, and we will be happy to answer them before we close out. Do we have any additional questions? Yes. Okay, so one just popped in, Terry. For us to discern whether something is PHI, would it be safe to assume anything from Anthem, Blue Cross, United, or any other healthcare companies would trigger PHI?
I mean, that's probably a safe assumption. I mean, technically, it's possible that there could be information coming. Again, if it's not individually identifiable, if you get a report that says from one of the vendors saying, you know, the plan paid 42 claims last month for this particular prescription without identifiable information, that's technically not PHI. But I think it's Glennis, I don't know what you think, but it would certainly be safe to at least start with the assumption that any information from those vendors should be treated as PHI, or at least warrants a closer look.
I agree, Terry. I tend to treat almost everything as PHI that we get so we don't run into issues with something that I assume is not and it is. So I would definitely agree with you on that. There's another question. Is there some type of confirmation that says we attended this training so that if we are questioned, we have the training? Yes, you will get a survey at the end, Megan, and you would just sign off that you understand the HIPAA requirements and that you've attended this training, and that will be documentation that you did attend the training. The next question is, does the restaurant protocol for violation of HIPAA regarding PHI need to be posted on file somewhere in the restaurant? Um, Terry, do they have to post that somewhere, or since
No, no,
everybody
there's
doesn't have
no,
access, it just
no, it's not like the FMLA poster or any of those. There's no posting requirement under HIPAA.
okay. All right. Are there any other questions? We will send a copy of the recording out to everyone. Oh, I have another. Oh, okay, two more. Are we safe asking for a doctor's note to cover absences or missed work? This would be considered PHI, correct?
It would not be, well, it would not be, again, someone who doesn't show up for work or work, attendance at work. Health information submitted for that purpose is not PHI.
Nope, but it should be kept confidential and secure.
Correct.
Just want to reiterate that.
Yeah.
If we had leaders attend, how would they sign confirmation of training? Because when they put their email in when they came in, is gonna send them a survey if they did that when they entered. If not, we will be sending this training material to your directors and your managers so they can sign off directly that way as well. Um, will the survey be sent via email to each participant? It will be sent to all operators and along with the video recording, and then your directors and your managers as well. Is there a quick reference guide somewhere that lists and clarifies what is and is not considered PHI? So I'm
We have this deck is probably, those few slides in this deck are probably the best and easiest thing, which I think they'll get a copy of this, correct?
yes, they will get a copy of the deck. So those slides will be your quick reference there. Are there any other questions before we stop for the day? All right. I don't think there are any other questions at this time, Terry. Thank you so much for conducting our training today. Everybody, we will send a copy of this out to everyone so that you can have that, and make sure that your directors or managers and your admin sign off on this training as well. And it will be emailed out to you as well as posted on GIOA.info for you to access at any time. We're going to stop the recording here, but if anybody else has any questions, we'll hang around for a minute to answer any additional questions.